Oh, okay, all right.
Right here, yeah. Low.
Okay, yeah, that's one of those seats that's about to bust out the bottom there. Be careful. Okay, so got both mics lit up, and this is House Bill 1221. If you
Yep.
would tell us about your bill.
Sure. Thank you very much, Chairman. So yes, as you said, House Bill 1221, it's LC 0416S. So at its core, this is a consumer protection bill. What it does is it protects consumers by disincentivizing unnecessary litigation in the HOA context, homeowners association context, and it also disincentivizes the collection of excessive attorney's fees by the HOA against a homeowner. So I have Bob Schwartz here. He is an attorney. He is my constituent, and he is the one that brought to my attention the need for this legislation. I will let him tell you about the case that he has been working on that I think really exposes the gaps in our current law. And I believe that you will agree, once you have heard from him, that the current law as it stands leads to some very unfavorable and very unfair results. So take it away, Bob.
I'd like to thank everybody for giving me this opportunity to speak. I'll try to keep it short. I know you got a long agenda.
Okay.
My name is Robert Schwartz. I'm an attorney. I'm speaking in favor of this bill. My interest comes from a case where I represented a homeowner in Cherokee County who had a situation with his homeowners association. Bought this property at the beginning of 2019. Payments at that time were $70 a month. He arranged for them to be deducted directly by auto pay from his checking account, and it went on fine. For 4 years, never missed a payment. The HOA changed management associations, and that management association didn't know auto pay. They didn't do auto pay. He didn't know about it. So his fees went unpaid for about 10 months, and then they sued him. He got served with them the following January, so by that time, they were 12 months behind. He came to consult me. First thing we did was call the lawyer on the other side. They told us what happened, and my client went right on down, and he wrote him a check, paid all the delinquent fees and the late charges and the interest. But the attorney's fees were $1,920. We offered to split them 50-50. The HOA said no. And so the lawsuit went on. This is in February of 2020, and the pandemic comes along, and by the time we get to trial, 3 years has gone by, and for some reason, they've piled up $2,900 worth of additional attorney's fees in the 3 years while we're waiting for trial. But now they're looking for $4,800. We have a trial, a bench trial. The judge knocks off some of the attorney's fees as having been unreasonable, and my guy's sitting there with a huge thing. He offers to pay it in voluntary monthly payments. The HOA says no, they don't trust him. They put a garnishment in place. It's all right. He makes enough money. He lives with the garnishment. 7 months later, it's paid in full. And we get a letter on January 9th of 2024 that says the judgment is paid in full. And then the letter says, we're only going to charge you $2,799 of additional post-judgment fees. And my guy says, we say, no way. So now, from January of 2024, they keep sending letters. By July of 2025, it's another $1,800. And we haven't gone to trial. They haven't sued him, but they're demanding $3,800, some of which is post-judgment, and some of which is post-payment of the judgment. And so what we want is this. If my guy had received a certified letter at the very beginning of this that said, you know, your payments aren't being made and we want to start collecting the debt, he has the opportunity to go in and pay it, which is what he did as soon as he found out. Certified letters are required for foreclosures in Georgia.
It would obviate the need for a legal proceeding.
And if he'd have a reasonable opportunity to cure, 10 days, 20 days, 30 days, he could have beaten that at all. And this thing would have been gone. No lawsuit, not all these extra expenses.
So I think, this bill that we proposed is very simple. What it does is it provides notice to the homeowner that they haven't been paying their homeowners association fees, that there's missed payments. It gives them a reasonable time to be able to cure that before attorney's fees kick in. And to the extent there is litigation, it has the reasonable attorney's fees must be listed, and there has to be a judgment that says that they are in fact reasonable before they can be paid. So again, it's just, the policy from policy perspective, it's to disincentivize frivolous actions, more litigation than necessary, and to keep attorney's fees down. And then I just, the scope of this is, I want to put it in perspective. I mean, once these kind of legal proceedings start against a homeowner, there can be a lien put up against their property. So the risk to the homeowner is significant if legal proceedings are started. So being able to disincentivize them, I think, has multiple public policy interests. We have been working very closely with the homeowner association lobby. They are not opposed to this bill. I don't know if Rob's here to speak on the bill, but we do have some tweaks based on those conversations that at the appropriate time we would love to present to the committee.
Okay, all right. I have a few people that have questions, but before I do that, I neglected to check on one of our members of the committee. Mary Margaret Oliver, are you there? Muted, okay. All right, we'll just make sure that she can hear us too.
I feel like this is a good time to mention she's a co-sponsor of the bill.
Ah, there you go. All right. I think 13 was first.
Thank you, Mr. Chairman. Mr. Schwartz, thank you for being here with us today. I can tell you're passionate about the issue. And if there's some changes I think are going to be offered, it may get to my question. One, on line 17, we say a reasonable amount of time to pay such outstanding fines and delinquent fees. I appreciate the reasonableness language for attorney's fees, but I almost wonder, should we define the amount of time that the lot owner would have? And if we do, what do you consider reasonable?
Okay.
And then I'll have a follow-up, Mr. Chairman.
I think 30 days. I think the lobbyist told us that 30 days is part of Fair Debt Collection Practices Act federal, which they have to abide by. And I think that's more than enough.
Thank you
I
for
didn't
that.
want to put a number in because I didn't know how to, but yes, 30.
Thank you. And then second, my other just concern and question is there are times when, as it's ongoing because of a delinquency that exists, the lot owner could be still incurring attorney's fees to the homeowners association. So how do we capture the fact that maybe on Monday they owe $1,000, but by Wednesday they owe $1,500? How do we capture that?
Well, they don't owe it. It's being asked for. They owe it when the judge awards.
Maybe let's say incurred. The homeowners association incurred.
And look, and to the extent that
I'd say when the work is being done, it's incurred. Then at trial, if you don't settle this thing, the judge is duty bound to make a reasonableness determination, which I mean, that's right I've got plenty of case law on that. So I would leave that up to the judge. If they're paying their lawyer, if they're writing a check to their lawyer and want to be reimbursed, let them explain to the judge why it was not unreasonable for them to do that.
So let me direct you to lines 20 through 23 of the bill. There are absolutely situations where the incurrence of attorney's fees is reasonable and is appropriate. And when that is the situation, the judge will have an opportunity to assess the attorney's fees and make a determination of what's reasonable and not to be paid.
What I'm just trying to figure out and make sure is that we're not, tilting the scale to say that something is reasonable just at the time when they send the letter and then the property owner doesn't. And I hate homeowners association. I'll just be clear, but we allow them to exist under law. And so I'm trying to operate inside of it myself. Is that, you don't have the judge stating, well, look, this is what they were notified of, and this should be part of the reasonable standard is what they were notified of, because you could get the letter, call the attorney on the letter, talk to him for an hour, and run up another $350 worth of fees. And that's what I'm just trying to balance here.
So part of the tweaks that we talked about with the homeowners association is to make sure it's clear in the law that the initial letter should not come from an attorney. The initial letter comes from the association or its agent. The idea being this is a form boilerplate level that would not incur any attorney's fees at that point. They have an opportunity to cure as the homeowner. Then if they don't do so, then probably you have to get your attorneys involved. And then there's probably incurrence of fees because the FDCPA is triggered. So this is an initial stage, hopefully before we get the lawyers involved. So like in the case of Bob's client, they had no idea they weren't paying fees at all, or they're missing payments at all, excuse me. A simple letter would have allowed them the opportunity to cure, and they never would have incurred any of those attorney's fees that they're facing now.
My concern is the attorney's fees that churn their fee, and the homeowners association doesn't want to have to sit there helpless with a stubborn litigant who makes them run up attorney's fees.
Appreciate
So I think we came up with a compromise that works. I was glad that the HOA representative took the time to speak with us. He made suggestions that we incorporated.
Yes.
He's a pretty good one.
All right, Representative Hong.
Thank you, Chairman. Thank you, Representative and Mr. Schwartz, for bringing the bill. I may have missed it. So with your client situation, they did not receive notice for the fees,
That's
any type of at all. They didn't even get their
They didn't.
annual notice or
Mhm.
monthly notice.
I'm not saying the notice wasn't sent out, but they didn't receive it. I
Okay,
have no idea whether it was sent out.
okay,
They billed $90 for doing it,
okay.
but it wasn't sent certified. And my
Your
client
client
said
just did not receive
he
it
claimed not to
despite
have
it
received it,
being
and they
said.
claimed to have written it. The person who wrote it and sent it out wasn't there at the hearing either.
Okay. And I have the same concerns. I mean, I think I have dealt with a lot of clients with where the fees may be small, but the attorney fees end up being so much that the homeowner ends up not being able to pay, despite the fact that they may be able to pay the fees incurred, but not the attorney fees. And so, but if they meet all of this and attorney fees are however much because they stayed on the phone for hours dealing with trying to make this work, we're still allowing those attorney fees to the reasonableness. Is that kind of where we're at
Yes.
with this bill?
That's exactly right.
And I wanted to add one thing. Georgia law understands this. MasterCard gets a percentage of attorney's fees, but in something like this, they're suing for small amounts. And you can't expect an HOA lawyer to be happy to get 15% of the $300 that he's suing to get. So the law as it is now is not unreasonable.
And what are, and if I can have just one more question, what have you been seeing as a reasonable attorney fees for, to a point where they've gotten to a point where litigation may happen?
What I'm seeing as reasonable attorney fees is however long it takes at $300 an hour.
Is
and
the average 300 an hour?
I've seen it.
It's unreasonable.
Yeah, unreasonable is Griffin Bell charging $1,800 an hour to send this letter. But we're not seeing that.
Investigative work, doing the work
Investigative work.
post judgment.
Post-judgment work,
Mhm.
unnecessary work. In my case, they were trying to bill for time spent preparing exhibits to prove things we had admitted in our answer and in discovery. And the judge knocked that off. He said, that's ridiculous. You shouldn't be charging for that.
Thank you.
I
Vice
hope
Chair
that
Reed.
was succinct enough.
Thanks for bringing this bill. I'll save my thoughts on HOAs, but, I know they do a lot of thankless work and I think due process and communication is something y'all are promoting and we could use a lot of that. On line 15, certified mail, due to issues with postal service and all that, would it be friendly to add or statutory overnight delivery? Would that be okay? So they can do FedEx or UPS?
Sure. I'm not used to being seated addressing a panel. Of course, in court, they don't allow that. And I appreciate it.
We'll move for that if it's not added in. Thank you.
Yeah. All right, that's all the questions I see. Oh,
Oh.
That's all right.
Representative Holcomb.
Thank you, Mr. Chairman. So I'm looking at the rest of the statute and it says that liens include any fees or assessments that are borne by the owners. And then in C, it already provides certified mail or statutory overnight delivery for the HOA to then address any of these liens. And then in B3, it provides for the cost of collection, including court costs, the expenses required for the protection and preservation of the lot, and reasonable attorney fees actually incurred. So how does this interrelate to what's already within
Interesting.
the statute?
We've received those notices. They've never, the B and C notices that you talked about, they've never come by certified mail. They're just a general first-class letter. That was one of the problems we had here to begin with. But also, the difference, the lien is provided in the covenants to begin with, but it's an inchoate lien. It doesn't become coate until they send this letter and file something in Superior Court. When it becomes coate, now judgments and 5-phase that come behind it are subordinate to it. And that's why the requirement is up there for certified or overnight and an opportunity to respond. And yet in practice, I'm not seeing those certified letters. I never have. In fact, the letters come to me instead of my client. After the judgment, and I'm no longer specifically representing him, they're sending these additional collection letters to me and not CCing my client.
This isn't my area of the law, but wouldn't that be an affirmative defense that they're not complying with the statute?
And it will be if if these post-judgment fees come in front of the Cherokee County judge. At this point, you know, they were not an issue. They were not an issue at the time.
Okay.
But I mean, the point is well taken. I wish they'd comply with it.
Thank you.
Representative Reeves.
Anytime things get so bad, we have to fix state law to take care of somebody's problem. I like to get the names out there. Who was the HOA? Who were the management companies?
Association. And the law firm was Luder, Larkin, and I forget the third name. They are notorious for this. I have another client who is also being sued for post-judgment, not being sued. She's getting letters for post-judgment fees. I've gone all the way up to Alpharetta to speak with them, the lawyers in person, and they insist that every single thing is justified. By now, they're asking her she paid the judgment in full, got delinquent again, paid a second judgment in full, and now they're coming after her again for post-judgment fees that are in excess of $3,000.
Were management companies part of the problem here?
I do not know with this client. I think the management company was not a problem. It was just the fact that they switched and the auto pay stopped. These generations don't balance their checkbook. They look at an app in the morning and see whether there's money.
All
Does
right.
that answer your question?
Yes, thank you.
I don't see any more questions. What's the will of the committee?
Second.
All right, got a motion and a second. Any discussion?
Yes, Chairman, we do have a series of amendments that we agreed with the HOA locust.
Everybody should have that before them. Do you have anything in addition to that? All right,
We pretty much take them up. I would be about the what is reasonable time for my second.
Okay.
let's just go ahead and take that.
So on line 17, Mr. Chairman. I would strike from A through time and replace with 30 days from receipt of the certified mail required in subparagraph 1 of this code section 2, or excuse me, you don't need the 2 at the end, it's already there. So it would read, lot owners with 30 days from receipt of the certified mail required in subparagraph 1 of this code section. Receipt of instead of certified mail. Yeah. All right. So 30 days from receipt of the notice required. You like that better, Michael? Sounds good. That would be my amendment that I would offer, Mr. Chairman.
Okay.
I'll offer that in the form of a motion.
All right, I have a motion for an amendment. Is there a second?
Second.
All right, I've got a second on that. Any further discussion on that? Yeah, I'm gonna just go one at a time. All right, all those in favor say aye. Any opposed? All right, that'll be the First Amendment. And Vice Chair, you have.
Thank you, Mr. Chairman. On line 15, after certified mail, I move to add or statutory overnight delivery.
See that again, please. Where's that go?
After certified mail.
Oh, after certified mail. All right, do I hear a second?
Okay.
Any discussion?
While we're doing this, and I'll offer to the author of the amendment, do we want to have a conversation about using an electronic mail address that has been provided to the homeowners association if it has been? Like we accept service for our legal proceedings, Mr. Schwartz, or to the author, do y'all have thoughts on
In addition to, as opposed to lieu of.
in addition to? Okay. I think they could probably already do that if they want to in addition to. I don't know if I want to put it as another requirement. I was going to allow it to be in lieu of.
I would go with the authors on that because I think there's probably some experience on
Okay.
that.
Then
And
I'll
it
put,
is. Sometimes I have a client right now, she's 84. She's computer illiterate. If she doesn't receive a phone call or a piece of letter in the mail, she doesn't know what's happening. And they're out there, in everybody's district, there's somebody who's 80 years old, owns a home, and doesn't know what email notice is.
I was bringing it up for discussion, Mr. Chairman, and I've been thoroughly educated.
Thank you. Thank you. All right, any further discussion? Hearing none, all those in favor of,
Some amendments from the homeowners association?
to this amendment?
No, to the original.
I'm taking them one at a time. So, all right,
Excuse me.
all those in favor of this amendment, say aye. Any opposed? Okay, we got that one. And I don't see anything else, so go ahead and start with yours.
Thank you, Chairman. So beginning at line 14, and Mr. Perry does have a copy of this. But at line 14, it would say before an association may collect or be awarded attorney's fees, it shall provide. And then continuing on to line 15, an initial written notice by certified mail or statutory overnight delivery to the lot owner from the association or its agent, identifying any outstanding fines or delinquent fees. And then on line 19, where it says an itemized list of attorney's fees claimed, the addition of comma, if any.
All right, basically, you're using the wording here.
Yes.
Okay, is there any addition to it?
Well,
You make the change 17.
17.
That's all.
correct. And then if you just want to delete lines 20 through 23, just don't look at lines 20. I made changes on there, but don't incorporate those changes on lines 20 through 23.
So just strike that off.
I mean, it should stay in the bill, but the changes that I've made there do not incorporate.
The changes you have that's listed here is on lines 14, 15,
And 19.
and 19.
May collect or be awarded attorney's fees. 14.
Okay, did you want to leave reasonable in there?
I do not.
Okay. Representative Hall.
Thank you, Mr. Chairman. So all we're doing to make sure that I understand is just the initial notice. And so if this lingers on for years and years and years. You don't get a second one. That will just be decided at trial. It's just the initial estimate or incurred fees, correct? Okay.
Yes.
You ready for the motion?
Yes, sir.
All right, so, Mr. Chairman, I would move to make the following amendments to LC 620416S as already amended. On line 14, after the word association, I would insert the word may and strike the word can. And then, but after the word collect, I would insert or be awarded and then strike the word reasonable. On line 15, I would add before the word written, the words an initial. And then we've already added or statutory overnight delivery after certified mail, but after the word owner and before the word identifying would add from the association or its agent. And then on line 19, after the word claimed at the end of that line and before the period, I would add comma, if any. And I believe that's everything.
Okay.
For those of us following at home, playing our home version of the game, I believe those are all the changes.
All right.
Thanks.
All right, got a motion and a second. Any further discussion? All those in favor say aye. Any opposed? All right. Now on to the bill. Any further discussion on the bill as amended? All those in favor say aye. Any opposed? All right, you got your bill.
Thank you very much. Thank you.
And thank you to everybody that asked questions.
And that didn't ask questions.